even more clearly that that cannot possibly be the basis for an impeachable offense. And even the House managers, as they have framed their case, they have explained, and this is pointed out in our trial memorandum, that in the House Judiciary Committee report, they specify that the standard they have to meet is to show that this is a sham investigation. It's a bogus investigation. These investigations there's not any legitimate public purpose. That's the language, any legitimate public purpose. That's the standard they've set for themselves in being able to make this claim under their theory of what an abuse of power offense can be. So it's a very demanding standard that they've set for themselves to meet. And they've even said they came up and they talked a lot about the Bidens. They talked a lot about these issues in 2016 election interference because they were saying there's not even a scintilla of any evidence of anything worth looking into there. And that's the standard that they would have to meet, showing that there's no possible public interest and the president couldn't have had any smidgen even of a public interest motive because they recognize that once you get into a mixed motive situation, if there's both some personal motive but also a legitimate public interest motive, it can't possibly be an offense. Because it would be absurd to have the Senate trying to consider, well, was it 48% legitimate interest and 52% personal interest, or was it the other way? Was it 53% and 40%? You can't divide it that way. And that's why they recognize that to have even a remotely coherent theory, the standard they have to set for themselves is establishing there is no possible public interest at all for these investigations. And if there is any possibility, if there is something that shows a possible public interest and the president could have that possible public interest motive, that destroys their case. So once you're into mixed motive land, it's clear that their case fails. There can't possibly be an impeachable offense at all. And think about it. All elected officials, to some extent, have in mind how their conduct, how their decisions, their policy decisions will affect the next election. There's always some personal interest in the electoral outcome of policy decisions. And there's nothing wrong with that. That's part of representative democracy. And to go start saying now that, well, if you've got a part motive that's for your personal electoral gain, that that's somehow going to become an offense, it doesn't make any sense. And it's totally unworkable. And it can't be a basis for removing a president from office. So the bottom line is once you're into any mixed motive situation, once it is established that there is a legitimate public interest that could justify looking into something, just asking a question about something, the manager's case fails, and it fails under their own terms. They recognize that they have to show no possible public interest. There isn't any legitimate public interest. And they've totally failed to make that case. I think we've shown very clearly that both of the things that were mentioned, 2016 election interference and the Biden-Burisma situation, are things that raise at least some public interest. There's something worth looking at there. It's never been investigated in the Biden situation. Lots of their own witnesses from the State Department said that on its face, it appears to be a conflict of interest. It's at least worth raising a question about, asking a question about it. And there is that public interest, and that means their case absolutely fails. Thank you.
That was from earlier today, the very first question in the Senate questioning time. Now we're expecting the chamber to come back into session here any moment, as you can see on the screen. We don't control the camera, so when they come back in, we will quickly go inside the chamber for our gavel-to-gavel coverage here on C-SPAN 2. In the meantime, Mike, in Iowa, we're asking you folks today, what question would you want your senator to ask? Your senator, Senator Grassley, did get to ask a question, but what would you want them to ask?
Okay, a lady called in yesterday and brought up a good point. That would be my question, is why are the senators running for president being allowed to vote on impeachment? That just seems like it just doesn't make sense. So that would be my question. Thank you.
Okay. Ricky in Ashland, Pennsylvania. Hi, Ricky.
Doing? That was going to be my question, too. If the president was considered checking in on his opponent for the next election to make the change in it, that why are the senators running for president allowed to vote on the impeachment?
Okay. All right, Ricky, we can see also on your screen outside of the Senate chamber, the senators starting to make their way back in. And of course, they run into reporters along the way who want to ask them questions. There's camera stakeout positions, a couple of places, a few places throughout the Capitol outside of the chamber. And we'll see if these senators can make their way in so they can resume the proceedings this afternoon. Also want to share with you this tweet by Kyle Cheney, who broke this news earlier today that the Senate is back in. Live coverage here on C-SPAN 2.
Mr. Chief Justice, I have a question for the President's Counsel, and it's co-sponsored by Senators Rounds, Wicker, Ernst, Blackburn, Tillis, Kramer, Cotton, Sullivan, and McSally, all members of the Senate Armed Services Committee.
The senator from South Dakota, Oklahoma, excuse me. The senators ask the following question of the counsel for the president. Mr. Cipollone, as members of the Senate Armed Services Committee, we listened intently when Manager Crow was defending one of Senator Schumer's amendments to the organizing resolution last week, as he explained how he had firsthand experience being denied military aid when he needed it during his service. As you know, David Hale, Undersecretary of State for Political Affairs, confirmed that the lethal aid provided to Ukraine last year was future aid. Which would you say had the greater military impact? President Trump's temporary pause of 48 days on future aid that will now be delivered to Ukraine, or President Obama's steadfast refusal to provide lethal aid to Ukraine for 3 years, more than 1,000 days, while Ukraine attempted to hold back Russia's invasion and preserve its sovereignty?
Mr. Chief Justice, thank you, senators, for that question. And I think it was far more serious and far more jeopardy for the Ukrainians, the decision of the Obama administration to not use the authority that was given by Congress, that many of you all and many members of the House of Representatives voted for, giving the U.S. government the authority to provide lethal aid to the Ukrainians, and the Obama administration decided not to provide that aid. And multiple witnesses who were called in the House by the House Democrats testified that the United States policy towards Ukraine got stronger under the Trump administration, in part largely because of that lethal aid. Ambassador Yovanovitch, Ambassador Volker, others also testified that U.S. policy in providing that aid was greater support for Ukraine than what was provided in the Obama administration, particularly the provision of Javelin anti-tank missiles, which they explained were lethal and would kill Russian tanks and change the calculus for aggression for the Russians in the Donbass region in the eastern portion of Ukraine, where that conflict is still ongoing. In terms of the pause, the temporary pause on aid here, the testimony in the record, put aside what the House managers have said about their speculation, and they know what it's like to be denied aid. The testimony in the record is that this temporary pause was not significant. Ambassador Volker testified that the brief pause on releasing the aid was, quote unquote, not significant. And Undersecretary of State for Political Affairs David Hale explained that, quote, this was future assistance, not to keep the Army going now. So in other words, this isn't money that had to flow every month in order to fund current purchases or something like that. It was money, it's 5-year money. Once it's obligated, it's there for 5 years. And it usually takes quite a bit of time to spend all of it. So the idea somehow that during the couple of months in July, August, and up till September 11th, 55 to 48 days, depending on how you count it, that this was somehow denying critical assistance to the Ukrainians on the front lines right then. It's simply not true. And now the House managers have tried to pivot away from that because they know it's not true, and to say, no, it was the signal to the Russians. It was the signal of lack of support that the Russians would pick up on. But here again, it's critical. Even the Ukrainians didn't know that the aid had been paused. And part of the reason was they never brought it up in any conversations with representatives of the U.S. government. And as Ambassador Volker testified, representatives of the U.S. government didn't bring it up to them because they didn't want anyone to know. They didn't want to put out any signal that might be perceived by the Russians or by the Ukrainians as any sign of lack of support. It was kept internal to the U.S. government. They've pointed to some emails that someone at the Department of Defense or Department of State, Laura Cooper, received from unnamed embassy staffers suggesting that there was a question about the aid. But her testimony was she couldn't even remember what the question really was, and she didn't want to speculate. There's not evidence that any decision makers in the Ukraine government knew about the pause. And just the other day, another article came out, I believe it was from at the time, the Foreign Minister Daniluk, explaining that when the Politico article was published on August 28th, there was panic in Kiev because it was the first time they realized there was any pause on the aid. So that was not something that was providing any signal either to the Ukrainians or the Russians because it wasn't known. It was 2 weeks later, after it became public, that the aid was released. The testimony in the record is that the pause was not significant. It was future money, not for current purchases, and it was released before the end of the fiscal year. They point out that some of it wasn't out the door by the end of the fiscal year. That happens every year. There's some percentage that doesn't make it out the door by the end of the year. And again, it's 5-year money. It's not like it's all going to be spent in the next 30, 60, 90 days anyway. So the fact there was a little fix, Congress passed a fix to allow that $35 million to be spent. Something similar happens for some amount almost every year, and it was not affecting current purchases. It wasn't jeopardizing anything at the front lines. There's no evidence about that in the record. The evidence is to the contrary. Thank you.
Thank you, counsel.
Mr. Chief Justice.
Senator from Maine.
Mr. Chief Justice, I have a question for both sets of counsel, which I'm sending to the desk.
The question from Senator King is for both counsel to the President and the House managers. President Trump's former Chief of Staff, General John Kelly, has reportedly said, quote, "I believe John Bolton," end quote, and suggests Bolton should testify, saying, quote, "If there are people that could contribute to this, either innocence or guilt, I think they should be heard," end quote. Do you agree with General Kelly that they should be heard? I think, counsel for the President, it's your turn to go first.
Thank you, Mr. Chief Justice, members of the Senate. This was a bit of a topic that I discussed yesterday, and that was the information that came out in the New York Times piece about what is purportedly in a book by Ambassador Bolton. Now, as I've said, the idea that a manuscript that's not in the book, there's not a quote from the manuscript in the book, this is a perception of what the statement might be. There have been very forceful statements, not just from the President, but from the Attorney General. The Department of Justice stated that while the Department of Justice has not reviewed Mr. Bolton's manuscript, The New York Times account of this conversation grossly mischaracterizes what Attorney General Barr and Mr. Bolton discussed. There was no discussion of, and this again, personal favors or undue influence on investigations, nor did Attorney General Barr state that the President's conversations with foreign leaders were improper. So again, that goes to some of the allegations that were in the article. The Vice President said the same thing. He said, in every conversation with the President and Vice President in preparation for our trip to Poland, the President consistently expressed his frustration that the United States was bearing the lion's share of responsibility. There's also an interview that Ambassador Bolton had given, I think in August, about the conversation where he said it was a perfectly appropriate conversation. I think that information's publicly available now. So again, to move that into a change in proceeding, so to speak, I think is not correct. The evidence that has already been presented, a accusation that if you get into witnesses, I'll do this very briefly, if we get down the road on the witness issues, let's be clear, it should not be, I certainly can't dictate to this body, it should certainly not be, though, that the House managers get John Bolton and the President's lawyers get no witnesses. We would expect if they're going to get witnesses, we will get witnesses, and those witnesses would then, but all of that, just to be clear, changes the nature and scope of the proceedings. They didn't ask for it before.
Thank you, counsel.
Senator Justice, what's the significance of the President's former Chief of Staff saying that he believes John Bolton and implicitly does not believe the President, that Bolton should testify? It's really, at the end of the day, not whether I believe John Bolton or whether General Kelly believes John Bolton, but whether you believe John Bolton. Whether you'll have an opportunity to hear directly from John Bolton, whether you have the opportunity to evaluate his credibility for yourself. Now, there are a few arguments made against this. Some are rather extraordinary. It would be unprecedented, the suggestion, I think, is to have witnesses in a trial. What an extraordinary idea. But as my colleagues have said, it would be extraordinary not to. This will be the first impeachment trial in history that involves no witnesses if you decide you don't want to hear from any, that you simply want to rely on what was investigated in the House. That would be unprecedented. Yes, we should be able to call witnesses, and yes, so should the President. Relevant witnesses. Now, the President says that you can't believe John Bolton, and Mick Mulvaney says you can't believe John Bolton. Well, let the President call Mick Mulvaney, another relevant witness with firsthand information. If he's willing to say publicly, not under oath, that Bolton is wrong, let him come and say that under oath. Yes, we're not saying that just one side gets to call witnesses, both sides get to call relevant witnesses. Now, they also make the argument implicitly, well, this is going to take long. Senator's got to warn you, if you run a real trial, it's going to require witnesses, and that's going to take time. And I think the underlying threat, and I don't mean this in a harsh way, but is we're going to make this really time-consuming. The deposition took place very quickly in the House. We have a perfectly good Chief Justice behind me that can rule on evidentiary issues. What's more, the President has waived and waived and waived any claim about national security here by talking about himself, by declassifying the call record. We're not interested in asking John Bolton about Venezuela or other places or other countries, just Ukraine. And if there's any question about it, the Chief Justice can resolve. These are relevant questions to the matter at hand. What you cannot do is use privilege to hide wrongdoing of an impeachable kind and character.
Thank you, Mr. Manager. The Senator from Utah.
I send a question to the desk on behalf of myself and Senators Cruz and Hawley.
The question is directed to counsel for the President. Is it true that Sean Misko, Abigail Grace, and the alleged whistleblower were employed by or detailed to the National Security Council during the same time period between January 20, 2017 and the present? Do you have reason to believe that they knew each other? Do you have any reason to believe that the alleged whistleblower and Misko coordinated to fulfill their reported commitment to, quote, do everything we can to take out the president, end quote?
Mr. Chief Justice, Senators, the only knowledge that we have, that I have of this, comes from public reports. I gather that there is a news report in some publication that suggests a name for the whistleblower, suggests where he worked, that he worked at that time while detailed the NSC staff for then Vice President Biden, and that there were others who worked there. We have no knowledge of that other than what's in those public reports, and I don't want to get into speculating about that. It is something that, to an unknown extent, may have been addressed in the testimony of the Inspector General of the Intelligence Community before Chairman Schiff's committees, but that testimony, contacts with the whistleblower, contacts between members of Manager Schiff's staff and the whistleblower are shrouded in secrecy to this day. We don't know what the testimony of the ICIG was. It remains secret. It has not been forwarded. We don't know what Manager Schiff's staff's contact with the whistleblower have been and what connections there are there. It's something that would seem to be relevant since the whistleblower started this entire inquiry, but I can't make any representations that we have particular knowledge of the facts suggested in the question. We know that there was a public report suggesting connections and prior working relationships between certain people. Not something that I can comment on other than to say that there's a report there. We don't know what the ICIG discussed. We don't know what the ICIG was told by the whistleblower. Other public reports about inaccuracies in the whistleblower's report to the ICIG. We don't know the testimony on that. We don't know the situation of the contacts, coordination, advice provided by Manager Schiff's staff to the whistleblower. That all remains unknown, but something that obviously, to get to the bottom of motivations, bias, how this was all, this inquiry was all created, could potentially be relevant. Thank you.
Thank you, counsel. The senator from New Mexico.
Mr. Chief Justice, I send a question to the desk for the President's counsel.
When did the President's counsel first learn that the Bolton manuscript had been submitted to the White House for review, and has the President's counsel or anyone else in the White House attempted in any way to prohibit, block, disapprove, or discourage John Bolton or his publisher from publishing his book?
Thank you, Mr. Chief Justice, and thank you, Senator, for the question. At some point, I don't know off the top of my head the exact date. The manuscript had been submitted to the NSC for review. It is with career NSC staff for review. The White House counsel's office was notified that it was there. The NSC has released a statement explaining that it has not been reviewed by anyone outside NSC staff. In terms of the second part of the question, has there been any attempt to prevent its publication or to block its publication? I think that there was some misinformation put out into the public realm earlier today And I can read for you a relatively short letter that was sent from NSC staff to Charles Cooper, who is the attorney for Mr. Bolton, on January 23rd, which was last week, which says, "Dear Mr. Cooper, thank you for speaking yesterday by telephone. As we discussed, the National Security Council Access Management Directorate has been provided the manuscript submitted by your client, former Assistant to President John Bolton, for pre-publication review. Based on our preliminary review, the manuscript appears to contain significant amounts of classified information. It also appears that some of this classified information is at the top secret level, which is defined by Executive Order 13526 as information that, quote, reasonably could be expected to cause exceptionally grave harm to the national security of the United States without authorization. Under federal law and the non-disclosure agreements your client signed as a condition for gaining access to classified information, the manuscript may not be published or otherwise disclosed without the deletion of this classified information. The manuscript remains under review in order for us to do our best to assist your client by identifying the classified information within the manuscript, while at the same time ensuring the publication does not harm the national security of the United States. We will do our best to work with you to ensure your client's ability to tell his story in a manner that protects U.S. national security. We will be in touch with you shortly with additional, more detailed guidance regarding next steps that should enable you to revise the manuscript and move forward as expeditiously as possible. Sincerely," and then the signature of the career official. So it is with the NSC doing their pre-publication review. Through his lawyer, Ambassador Bolton was notified that the manuscript he submitted contains a significant amount of classified information, including at the top secret level, so that in its current form, it can't be published, but that they will be working with him as expeditiously as possible to provide guidance so it can be revised and so that he can tell his story. And that was the letter from the NSC that went out. Thank you.
Thank you, counsel.
Mr. Chief Justice.
The senator from Iowa.
Mr. Chief Justice, I send a question to the desk on behalf of myself and Senators Burr, McSally, Daines, Moran, Young, and Sass.
The senator's question is directed to counsel for the president. Is it true the Trump administration approved supplying Javelin anti-tank missiles to Ukraine? Is it also true this decision came on the heels of a nearly 3-year debate in Washington over whether the United States should provide lethal defense weapons to counter further Russian aggression in Europe? By comparison, did President Obama refuse to send weapons or other lethal military gear to Ukraine? Was this decision against the advice of his defense secretary and other key military leaders in his administration?
Mr. Chief Justice, thank you, Senators, for the question. Yes, the Trump administration made the decision to provide Javelin anti-tank missiles, and there was a significant debate about that for some time. Authorization had been granted by Congress, and many of you voted for that statutory authorization during the Obama administration to provide lethal assistance to Ukraine. But the Obama administration decided not to provide that. It was only the Trump administration that made that lethal assistance available. And there was a significant amount of testimony in the House proceedings that President Trump's policy towards Ukraine was actually stronger. Ambassador Volker explained that America's policy toward Ukraine has been strengthened under President Trump, and that each step along the way in the decisions that got to the Javelin missiles being provided was made by President Trump. It is something that has substantially strengthened our relationship with Ukraine and strengthened their ability to resist Russian aggression. Ambassador Yovanovitch said that President Trump's decision to provide lethal weapons meant that our policy actually got stronger over the last 3 years, and she called it very significant. And another point to make in relation to this is, again, that the temporary pause that took place over the summer is something that the Ukrainian Deputy Defense Minister described as being so short that they didn't even notice it. So President Trump's policies across the board have been stronger than the prior administration's in providing defensive capability, lethal defensive capability, to the Ukrainians. And I think that that's significant. The specific part of the question, Senators, whether it was contrary to the advice of the President's Defense Secretary and others, I believe that that is accurate. It was against the advice of the Secretary of Defense. It was President Trump's decision to provide this lethal assistance, and that has been made public in the past. Thank you.
Thank you, Counsel. Senator Feinstein.
Thank you, Mr. Chief Justice. I send a question to the desk on behalf of Senator Carper, Coons, Hirono, Leahy, Tester, Udall, to the House managers, and on behalf of myself. Thank you.
Senator Feinstein and the other senators is to the House managers. The President has taken the position that there should be no witnesses and no documents provided by the executive branch in response to these impeachment proceedings. Is there any precedent for this blanket refusal to cooperate, and what are the consequences if the Senate accepts this position here?
Mr. Chief Justice and Senators, President Trump has taken really an extreme measure to hide this evidence from Congress. No president has ever issued an order to direct a witness to refuse to cooperate in an impeachment inquiry before this. Despite his famous attempts to conceal the most damaging evidence against him, even President Nixon allowed senior officials to testify under oath. Not only did he allow them, he told them to go to Congress voluntarily and answer all relevant questions truthfully. But President Trump issued a blanket order directing the entire executive branch to withhold all documents and testimony from the House of Representatives. This order was categorical, it was indiscriminate, unprecedented. Its purpose was clear: to prevent Congress from doing its duty under the Constitution, to hold the president accountable for high crimes and misdemeanors. Telling every person who works in the White House and every person who works in every department, agency, and office of the executive branch is just not precedented. It wasn't about specific, narrowly defined privileges. He never asserted privileges. And the President's counsel has mentioned over and over that he had some reason because of the subpoenas. Well, I'll tell you, we adopt rules about subpoenas in the House. The Senate is a continuing body, but the House isn't. And in January, we adopted our rules, and it allows the committee chairman to issue subpoenas. And that's what they did. He refused to comply with those subpoenas, not because he exerted executive privilege, because he didn't like what we were doing. He tried to say it was invalid, but it was valid, and actually, he doesn't have the authority to be the arbiter of the rules of the House. The House is the sole arbiter of its rules when it comes to impeachment. Now, this refusal to give testimony documents, like, it's still going on. we still have former or current administration officials who are refusing to testify. We would not allow this in any other context. If a mayor said, I'm not going to answer your subpoenas, they'd be dealt with harshly if it was to cover up misdeeds and crimes as we have here. So mayors have actually gone to jail for doing that. If we allow the president to avoid accountability by simply refusing to provide any documents, any witnesses, unlike every single president who preceded him, we're opening the door not just to eliminating the impeachment clause in the Constitution. Try doing oversight. Try doing oversight, senators, and we're thinking about that in the House. If the president can just say, we're not sending any witnesses, we're not sending any documents, we don't have to, we don't like your processes, we have a wholesale rejection of what you're doing. That's not the way our Constitution was created, where each body has a responsibility. There's a sharing of power. And I know you, cherish the responsibility that we have. That will be eviscerated if the president's complete stonewalling is allowed to persist and be accepted by this body. You have to act now in this moment of history. I yield back.
Thank you.
Mr. Chief Justice.
Senator from West Virginia.
Thank you. I send a question to the desk for the President's Counsel.
The senator's question is for counsel for the president. You said that Ukrainian officials didn't know about the pause on aid until August 28, 2019, when it was reported in Politico. But didn't Laura Cooper, the Deputy Assistant Secretary of Defense for Russia, say that members of her staff received queries about the aid from the Ukrainian embassy on July 25? Does that mean that Ukrainian officials knew about the hold on aid earlier than the Politico article?
Mr. Chief Justice. Members of the Senate, Senator, thank you for your question. It does not mean that. As we explained on Saturday, the overwhelming body of evidence indicates that the Ukrainians at the very highest levels, President Zelensky and his top advisors, only became aware of the pause in the security assistance through the August 28 Politico article. I addressed on Saturday, and so those comments will stand, the emails from the Deputy Assistant Secretary of Defense, Laura Cooper, testified about previously. What she had said was that her staff had gotten emails from someone at the State Department who had had some sort of conversation with Ukrainian officials here that somehow related to the aid at a time prior to August 28. She did not know the substance of the emails, nor whether they mentioned hold, pause, review, anything of that nature. And she even said herself that she didn't want to speculate as to what the emails mean and cannot say for certain what they were about. I presented on Saturday the evidence, which again, referencing the common sense that would be in play here. This was something that on August 28th caused a flurry of activity among the highest-ranking Ukrainian officials. Never before did they raise any questions at any of the meetings they had with the high-ranking U.S. officials through July and August. There were meetings on July 9, July 10, July 25 call, July 26, and August 27. At none of those meetings was the pause on aid revealed or inquired about. However, as soon as the Politico article came out, on August 28th, within hours of that Politico article coming out, Mr. Yermak texted the article to Ambassador Volker and asked to speak with him. That's consistent with someone finding out about it for the first time. The Ukrainians have also made statements that they learned about it for the first time, and then Mr. Philbin just referenced an article that came out yesterday in the Daily Beast, which was an interview with Mr. Daniluk, who was at the time a very high-ranking defense official with the Ukrainians. And this is interesting, and I'm going to read this article because I think it's important, and I suggest it to the Senate if they wish to have something to consider further on this. Daniluk said he first found out that the U.S. was withholding aid to Ukraine by reading Politico's article published August 28. U.S. officials and Ukrainian diplomats, including the country's foreign minister, Elena Zerkal, have said publicly that Kiev was aware that there were problems as early as July. And that's the article that they've mentioned in the statement that the House members have mentioned. Here's Mr. Daniluk. I was really surprised and shocked because just a couple of days prior to that, I actually had a meeting with John Bolton. Actually, I had several meetings with him, and we had extensive discussions. The last thing I'd expected to read was an article about military aid being frozen, Daniluk said. After that, I was trying to get the truth. Was it true or not true? Daniluk said that it was a panic inside the Zelensky administration after the initial news broke, saying Zelensky was convinced there had been some sort of mistake. That's President Zelensky. Daniluk put in calls to the National Security Council, and asked other officials in Washington what to make of the news, again on August 28th, or right after August 28th. The next time we met in September, it was in Poland for the commemoration of the beginning of the Second World War, the Warsaw meeting we've discussed previously. Daniluk said, adding that he met with Bolton on the sidelines of the commemoration. I had my suspicions. There was a special situation with one of our defense companies that were acquired by the Chinese, and the U.S. was concerned about this. Bolton actually made the public comments about this as well. So somehow I linked this to things and tried to understand, okay, maybe this could be related to this. So not only did they not know until August 28th, when they did find out, they didn't link it to any investigations. Where's the quid pro quo? If this is such the forefront of their minds, such pressure on them that the Ukrainians have to do these investigations to get the aid, when the aid was held up, they didn't think it was connected to the investigations. Thank you, counsel.
Thank you, Mr. Chief Justice. The senator from Maryland.
Mr. Chief Justice, I have a question on behalf of Senator Baldwin and myself I sent to the desk.
The question is addressed to the House managers. Is the White House correct in its trial memorandum and in presentations of its case that, quote, President Zelensky and other senior Ukrainian officials did not even know that the security assistance had been paused, end quote, before seeing press reports on August 28, 2019, which was more than a month after the July 25 phone call between Presidents Zelensky and Trump?
Thank you, Chief Justice and Senators, for the question. The answer is no. The evidence does not show that. We know that Defense Department official Laura Cooper testified that her staff received 2 emails from the State Department on July 25th, revealing that the Ukrainian embassy was, quote, asking about security assistance. And in fact, counsel for the president brought up these emails just now. So I would propose that the Senate subpoena those emails so we can all see for ourselves what exactly was happening. We also know that career diplomat Catherine Croft stated that she was, quote, very surprised at the effectiveness of my Ukrainian counterparts' diplomatic tradecraft, as in to say they found out very early on or much earlier than I expected them to, end quote. and that Lieutenant Colonel Alex Vindman testified that by mid-August he was getting questions from Ukrainians about the status of security assistance. So the evidence shows over and over again from the House inquiry that there was a lot of discussion, and there should be. Because we also know that delays matter. They matter a lot. And you don't have to take my word for it. This is not just about a 48-day delay. The Ukrainians were consistently asking about it because it was urgent. They needed it. They needed it, and who else was asking for it was American businesses. The contractors who are going to be providing this were also making inquiries about it because there's a pipeline. And as my esteemed Senate Armed Services colleagues know very well, that providing aid is not like turning on and off a light switch. You have to hire employees. You have to get equipment. You've got to ship it. It takes a long time for that pipeline to go. And in fact, I had to come together as a Congress to pass a law to extend that timeline because we were at risk of losing it. And to this day, $18 million of that aid have still not been spent. But let's just assume for a minute, also broadly speaking, that the President's Council's argument that support for Ukraine has never been better than it is today. That under the Trump administration, they are the strongest ally the Ukraine has seen in years. So just assuming for a minute that argument to be true, it kind of makes our own argument. It kind of makes our argument. Then why hold the aid? Why hold the aid? Because nothing had changed in 16, nothing had changed in 17, nothing had changed in 18. One thing had changed in 19, and that was Vice President Biden was running for president. Lastly, the question before by my Senate Armed Services colleagues framed this in terms of the military impact. And they asked what was greater in terms of military impact, not providing lethal aid or a 48-day delay. Let's not forget the reason for the delay, because there's a lot of discussion today about the technicalities of the delay, and that the president's mentality, his mindset doesn't matter. It doesn't matter what he intended to do. But I would posit that's exactly why we're here. That it does matter what the president intended to do, because the American people, in matters of national security, deserve to go to bed every night knowing that the president, the commander-in-chief, the person who is ultimately responsible for the safety and security of our nation every night, has the best interests of them and their families in this country in mind, not the best interests of his political campaign. And that is why we are here.
Mr. Manager.
Mr. Chief Justice.
Senator.
I sent a question to the desk on behalf of myself and Senator Murkowski.
The question is to counsel for the President. Witnesses testified before the House that President Trump consistently expressed the view that Ukraine was a corrupt country. Before Vice President Biden formally entered the 2020 presidential race in April 2019, did President Trump ever mention Joe or Hunter Biden in connection with corruption in Ukraine to former Ukrainian President Poroshenko or other Ukrainian officials, President Trump's cabinet members or top aides, or others? If so, what did the President say to whom and when?
Mr. Chief Justice, Senators, thank you for that question. Of course, I think it's important at the outset to frame the answer by bearing in mind I'm limited to what's in the record, and what's in the record is determined by what the House of Representatives sought. It was their proceeding. They were the ones who ran it. They were the ones who called the witnesses. So part of the question refers to conversations between President Trump and other cabinet members and others like that. There's not something in the record on that. It wasn't thoroughly pursued in the record. So I can't point to something in the record that shows President Trump at an earlier time mentioning specifically something related to Joe or Hunter Biden. It is in the record that he spoke to President Poroshenko twice about corruption in the Ukraine, both in June of 2017 and again in September of 2017. But there is other information publicly available and in the record that I think is important for understanding the timeline and understanding why it was that the information related to the Bidens and the Burisma affair came up when it did. So one important piece of information to bear in mind is President Poroshenko was the person that Joe Biden himself, on the tapes we've seen, went to have the prosecutor fired. So as long as President Poroshenko was still in charge in Ukraine, he was the person that Joe Biden had spoken to get the prosecutor, Shokin, fired when Shokin was looking into, according to public reports, looking into Burisma. As long as he was still the president in Ukraine, questioned the utility of raising an incident in which he was the one who was taking the direction from Vice President Biden to fire the prosecutor. So when you have an election in April of 2019, and you have a new president, President Zelensky, who is run on an anti-corruption platform, and there is a question, is he really going to change things? Is there going to be something new in the Ukraine? It opens up an opportunity to start looking really at anti-corruption issues and raising questions. Now, the other important thing to understand in the timeline is that we've heard a lot about Rudy Giuliani, the president's private lawyer, and what was he interested in Ukraine, and what was his role? Well, as we know, it's been made public, Mr. Giuliani, as the president's private lawyer, had been asking a lot of questions in the Ukraine dating back to the fall of 2018. And in November 2018, he said publicly he was given some tips about things to look into. He gave a dossier to the State Department in March of this year. Remember, Vice President Biden announces his candidacy in April 25th. In March, Rudy Giuliani gave documents to the State Department, including interview notes from interviews he conducted both with Shokin and with Yuri Lutsenko, who was also a prosecutor in the Ukraine. And those interview notes are from January 23rd and January 25th, 2019, so months before Vice President Biden announced any candidacy. And it goes through in these interview notes, Shokin explaining that he was removed at the request of Mr. Joseph Biden, the vice president. And it explains that he had been investigating Burisma and that Hunter was on the board. And it raises all of the questions about that. So it was Mr. Giuliani who had been, as Jane Raskin explained the other day as counsel for the president here, Mr. Giuliani, as counsel for the president, is looking into what went on in Ukraine. Is there anything related to 2016? Are there other things related there? And he's given this information, tips about this, and starts pursuing that as well. And he's digging into that in January of 2019. We know that Mr. Giuliani is the president's private counsel. I can't represent specific conversations they had. They would be privileged. But we do know from testimony that the president said in a May 23rd Oval Office meeting with respect to Ukraine, talk to Rudy. Rudy knows about Ukraine. So the president, it seems from that, gets information from Mr. Giuliani. Months before Vice President Biden announced his candidacy, Mr. Giuliani is looking into this issue, interviewing people and getting information about it. In addition, in March of 2019, articles began to be published. Then 3 articles were published by ABC, by the New Yorker, and by the Washington Post before the July 25th call. Washington Post on July 22nd, 3 days before the call, has an article specifically about the Bidens and Burisma. That's what makes it suddenly current, relevant, probably to be in someone's mind. So that's the timeline.
Mr. Chief Justice.
Senator from California.
Thank you. I sent a question to the desk on behalf of Senator Patty Murray and myself.
Senator Harris and Murray ask the House managers. The House of Representatives is now in possession of a tape of President Trump saying of Ambassador Maria Yovanovitch, quote, "Get rid of her, get her out tomorrow. I don't care, get her out tomorrow, take her out, okay, do it," end quote. President Trump gave this order to Lev Parnas and Igor Fruman, two men who carried out Trump's pressure campaign in Ukraine at the direction of Rudy Giuliani. Does the discovery of this tape suggest that if the Senate does not pursue all relevant evidence, including witnesses and documents, that new evidence will continue to come to light after the Senate renders a verdict?
The answer is yes. What we have seen really over the last several weeks since the passage of the articles in the House of Representatives is every week, indeed, sometimes every day, there is new information coming to light. We know there's going to be new information coming to light on March 17th when the Bolton book comes out. That is, if the NSC isn't successful in redacting it or preventing much of its publication. And on that issue, I do want to mention one other thing in response to the question about the Bolton manuscript and what did the White House lawyers know. Because I listened very carefully to the answer to that question, and maybe you listened more carefully than I did. What I thought I heard them say in the answer to that question, what did they know about the manuscript and when did they know it? Their statement was very precisely worded. The NSC unit reviewing the book did not share the manuscript. Well, that's a different question than whether the White House lawyers found out what's in it. Because you don't have to circulate the manuscript to have someone walk over to the White House and say, you do not want John Bolton to testify. Let me tell you, you do not want John Bolton to testify. You don't need to read his manuscript because I can tell you what's in it. So the denial was a very carefully worded one. I don't know what the White House lawyers knew and when they knew it, but they did represent to you repeatedly that the president never told a witness that he was freezing the aid to get Ukraine to do these investigations. And we know that's not true. You know that from the witnesses we've already heard from, but we also know, at least if the reporting is correct, and you should find out if it is, that John Bolton tells a very different story. So there are going to continue to be revelations, and members of this body on both sides of the aisle are going to have to answer a question each time it does, why didn't you want to know that when it would have helped inform your decision? In every other trial in the land, you call witnesses to find out what you can. Again, we're not a court of appeals here. We are the trial court. We're not confined to the record below. There is no below. Counsel says, in answer to the senator's question about whether Donald Trump ever brought up the Hunter Biden problem with President Poroshenko in the past, and says, well, we're confined to the record before us. You're not confined to the record in the House, nor is the president. The president could call witnesses if they existed. There's nothing to prevent them from saying, as a matter of fact, tomorrow we're going to call such and such, and they're going to testify that indeed Donald Trump brought up Hunter Biden to President Poroshenko. There's nothing prohibiting them from doing that. But at the end of the day, we are going to continue to see new evidence come out all the time. But among the most significant evidence, we know what that's going to be. And you know, the effort to suggest that, well, because this president was stronger on javelins than his predecessor, when we know from the July 25th call, the moment that Zelensky brings up the javelins, what's the very next thing the president says? He wants a favor. The question is, why did he stop the aid? Why did he stop the aid this year and no prior year? Was it merely a coincidence? Are we to believe it was merely a coincidence that it was the year that Joe Biden was running for president? Are we to believe that of all the companies and all the land, of all the gin joints and all the land in Ukraine, that it was just Hunter Biden walking into this one. That was the reason why that he was interested in Burisma was just a coincidence that involved the son of his opponent. But look, more and more is coming out. Let's make sure that you learn whatever you feel you need to know to render a judgment now when it can form your decision and not later.
Thank you, Mr. Manager.
Mr. Chief Justice,
The senator from Nebraska.
I send a question to the desk on behalf of myself, Senator Crapo, and Senator Risch.
Thank you. The senators ask counsel for the president. The President's Counsel has underscored the administration's ongoing anti-corruption focus with our allies. At what point did the United States government develop concerns about Burisma in relation to corruption and concerns with Russia?
That question, and I think it bears on the answer that I was last giving to the last question. This is something that became, of course, President Trump, in his conversation with President Zelensky in the July 25th call, as the transcript shows us, brought up a couple of things. He brought up burden sharing specifically, and he raised the issue of corruption in two specifics. The specific case of potential Ukrainian interference in the 2016 election, which he had heard about and asked about, and the incident involving the firing of a prosecutor who, according to public reports, had been looking into Burisma, the company that Vice President's son was on the board of. And that was the president's way of pinpointing specific issues related to corruption. So when did it become part of the president's concern, those issues related to corruption in Ukraine? Of course, we have the evidence that everyone in the government, Fiona Hill testified to this, thought that anti-corruption was a major issue for U.S. policy with respect to Ukraine. When there was a new president elected in April, President Zelensky, that brought the possibility of reform to the forefront. Then we know that the president was receiving information from his private attorney, Rudy Giuliani. And he spoke in the Oval Office of, Rudy knows about the Ukraine. You guys go talk to him, because he was explaining to the delegation that had just returned from the inauguration for President Zelensky, that he had concerns about Ukraine because they're all corrupt. And he kept saying, it's a corrupt country, I don't know. They tried to get me in the election. So it draws again, and there's his specific experience with Ukrainian corruption, because he knew from the public reports, as in the Politico article that has been referenced many times, the Politico article in January of 2017 explained a laundry list of Ukrainian government officials who had been out there attempting to assist the Hillary Clinton campaign and spread misinformation or bad information, or assist in digging up dirt on members of the Trump campaign. Mr. Giuliani had been investigating things related to Ukraine in 2016 and was led to the information about the Burisma situation and Vice President Biden having the prosecutor fired. So that was in January that he had these interviews. He turned over to the State Department in March. And then there were a series also of public articles published. John Solomon in The Hill published an article in March. Rudy Giuliani tweeted about it in March. There was an ABC story in June. There was a two-part New Yorker story about Biden's in Burisma in July. Then July 22nd, the Washington Post had an article and explained specifically on just July 22nd, this is 3 days before the July 25th call, the Washington Post reported that Mr. Shokin, the prosecutor, quote, believed his ouster was because of his interest in the company, end quote, referring to Burisma. And he said that, quote, had he remained in his post, he would have questioned Hunter Biden, end quote. So I think it is a reasonable inference that as there were these articles being published in close proximity to the time, this was information that was available to the president, and it became available to him as something that was a specific example of potentially serious corruption. And remember, everyone who testified, who was asked about it, does it seem like there's an appearance of a conflict of interest? Does it seem like that's fishy? Everyone testified below, yes, there's at least an appearance of a conflict of interest there. And I think it was after the information had come to Mr. Giuliani, long before Vice President Biden had announced his candidacy, that it came to the attention of the president and became something worth raising because, again, President Poroshenko is the one who fired the prosecutor. While he's still the president, it's not really as much of an opportunity or possibility of raising that. And so I think it was in that time frame, along that arc of the timing, that it came to the president's attention, and that's why it was raised in that timing. Thank you.
Mr. Chief Justice.
The senator from Connecticut.
Thank you, Mr. Chief Justice. I have a question for the counsel for the president.
Thank you. Senator Blumenthal asks, did anyone in the White House or outside the White House tell anyone in the White House counsel's office that publication of the Bolton book would be politically problematic for the president?
Thank you, Mr. Chief Justice. Thank you, Senator, for the question. No one from inside the White House or outside the White House told us that the publication of the book would be problematic for the president. I think we assumed that Mr. Bolton was disgruntled, and we didn't expect he was going to be saying a lot of nice things about the president, but no one told us anything like that.
So,
Mr.
the
Chief
senator
Justice,
from Texas.
I sent a question to the desk on behalf of myself and Senators Moran and Hawley. It is a question for the House managers.
Thank you. The question from the senators to the House managers. An August 26, 2019 letter from the Intelligence Community Inspector General to the Director of National Intelligence discussing the so-called whistleblower stated that the Inspector General identified some indicia of an arguable political bias on the part of the complainant in favor of a rival political candidate. Multiple media outlets reported that this likely referred to the whistleblower's work with Joe Biden. Did the so-called whistleblower work at any point for or with Joe Biden? If so, did he work for or with Joe Biden on issues involving Ukraine? And did he assist in any material way with the quid pro quo in which then Vice President Biden has admitted to conditioning loan guarantees to Ukraine on the firing of the prosecutor investigating Burisma?
Thank the senators for the question, and I want to be very careful in how I answer it so as not to disclose or give an indication that may allow others to identify the identity of the whistleblower. But first, I want to talk about why we're making such an effort to protect the identity of the whistleblower. If you could put up slide 48. This slide shows, and it may be difficult for some of you to read, so let me try to, actually, if you could hand me a copy of that as well. I have a chance to distribute that to everyone. It's not just that we view the protection of whistleblowers as important. Members of this body have also made strong statements about just how important it is to protect whistleblowers. Senator Grassley said this person appears to have followed the whistleblower protection laws and ought to be heard out and protected. We should always work to respect whistleblowers' requests for confidentiality. Senator Romney, whistleblowers should be entitled to confidentiality and privacy because they play a vital function in our democracy. Senator Burr, we protect whistleblowers, we protect witnesses in our committee. Even my colleague, the ranking member, Mr. Nunes, we want people to come forward and we will protect the identity of those at all cost. This has been a bipartisan priority and one that we have done our best to maintain. So I want to be very careful, but let me be clear about several things about the whistleblower. First of all, I don't know who the whistleblower is. I haven't met them or communicated with them in any way. The committee staff did not write the complaint or coach the whistleblower what to put in the complaint. The committee staff did not see the complaint before it was submitted to the Inspector General. The committee, including its staff, did not receive the complaint until the night before Acting Director of National Intelligence. We had an open hearing with the Acting Director on September 26, more than 3 weeks after the legal deadline by which the committee should have received the complaint. In short, the conspiracy theory, which I think was outlined earlier, that the whistleblower colluded with the Intel Committee staff to hatch an impeachment inquiry is a complete and total fiction. This was, I think, confirmed by the remarkable accuracy of the whistleblower complaint, which has been corroborated by the evidence we subsequently gathered in all material respects. So I'm not going to go into anything that could reveal or lead to the revelation of the identity of the whistleblower, but I can tell you, because my staff's names have been brought into this proceeding, that my staff acted at all times with the most complete professionalism. I am very protective of my staff, as I know you are. And I'm grateful that we have such bright, hardworking people working around the clock to protect this country and who have served our committee so well. And it really grieves me to see them smeared, and some of them mentioned here today have concerns about their safety, and there are online threats to members of my staff as a result of some of the smears that have been launched against them. I can tell you there's no one who can understand the plight of Ambassador Yovanovitch more than some of my staff who have been treated to the same kind of smears and now have concerns over their own safety. They acted at all times with the utmost propriety and integrity. Your Senate Intelligence Committee and your chairman and vice chairman can tell you, encourage whistleblowers to come to their committee, and so do we. And when they do, we try to figure out, is their complaint within the scope of jurisdiction of the intelligence community? And if it is, then we suggest they get a lawyer. We suggest they talk to the Inspector General, which is what happened here. The whistleblower did exactly what they should, except for the president. That's unforgivable, because the whistleblower exposed the wrongdoing of the president. In the president's view, that makes him or her a traitor or a spy. And as the president tells us, there's a way we used to treat traitors and spies. You wonder why we don't want to call the whistleblower? Well, first of all, we know firsthand what the whistleblower wrote secondhand in that complaint. There's no need for that whistleblower anymore, except to further endanger that person's life. That, to me, does not seem a worthwhile object for anyone in this chamber, on the other side of this building, in the Oval Office, or anywhere else.
Thank you, Mr. Manager. Senator from Rhode Island.
Mr. Chief Justice, on my own behalf and on behalf of Senators Blumenthal, Booker, Coons, Klobuchar, Leahy, Markey, Peters, and Udall, I send a question to the desk.
The question from Senator Whitehouse and the other senators to the House managers. The missing witness rule, which dates back to 1893 Supreme Court case Graves versus United States, allows one party to obtain an adverse inference against the other for failure to produce a witness under that party's control with material information. Here, one party, the President, has prevented witnesses within his control from testifying or providing documents. Do the House managers believe senators should apply the missing witness rule here, and if so, what adverse inferences should we draw about the missing testimony and documents?
Mr. Chief Justice, Senators, we do believe that you should draw an adverse inference against the party resisting the testimony of these witnesses like John Bolton. Courts have long recognized that when a party has relevant evidence within his control which he fails to produce, that failure gives rise to an inference that that evidence is unfavorable to him. Courts have frequently drawn adverse inferences where a party acts in bad faith to conceal evidence or preclude witnesses from offering testimony. And I would suggest that it is bad faith when counsel comes before you and says that if you really wanted these witnesses, you should have sued to get them in the House, and goes into the courtroom down the street and says, you can't sue to get witnesses before the House. But that's what's happened here. And you are, I think, not only permitted, but absolutely should draw an adverse inference that when a party is making that argument on both sides of the courthouse, that the evidence those witnesses would provide runs against them. Now, the administration hasn't produced a single document, not one, a single document. That's extraordinary. They can argue executive privilege and absolute immunity. Most of that has nothing to do with the overwhelming majority of these documents, not a whit. There's no absolute immunity from providing documents. The vast, vast majority don't have anything to do with privilege, and if they did, they would be redactions, very specific redactions. None of that happened. Are you allowed to draw an adverse inference that the reason why the President's team, which has possession of those emails regarding inquiries by Ukraine into why the aid was frozen, are you allowed to draw an inference, if they won't show you those emails, that those emails would confirm that Ukraine knew the aid was withheld, just like the former Deputy Foreign Minister of Ukraine said publicly when she told the New York Times, yes, we knew, by the end of July, we knew, this is the Deputy Foreign Minister at the time, we knew the aid was frozen, but I was instructed by Andrei Yermak not to mention it. I had a trip planned to Washington to talk to Congress. I was told not to go. Why? Because they didn't want it public. Are you entitled to draw an inference that those records, they refuse to turn over all those State Department records, the fact that they won't allow John Bolton's notes to be turned over, they won't let Ambassador Taylor's notes to be turned over? Should you draw an adverse inference? You're darn right you should. Now they say, well, the President only told Sondland no quid pro quo. They leave out the other half where Sondland told Taylor, but he said no quid pro quo, but you got to go to the mic and announce these investigations. Well, Ambassador Taylor wrote down the notes of that conversation. That took place right after that call with the President. Are you allowed to draw an adverse inference from the fact they don't want you to see Ambassador Taylor's notes, from the fact they don't want you to see Ambassador Taylor's cable? You're darn right you should draw an adverse inference. And finally, with respect to who has become a central witness here, I think the adverse inference screams at you as to why they don't want John Bolton. But you shouldn't rely on an inference here, not when you have a witness who's willing to come forward. There is no need for inference here. There's just a need for a subpoena.
Thank you, Mr. Manager.
Mr. Chief Justice,
Yes, Senator from South Dakota.
I have a question to send to the desk.
Thank you. Senator Thune's question is for counsel for the President. Would you please respond to the arguments or assertions the House managers just made in response to the previous questions?
Mr. Chief Justice, thank you, Senator, for the question. I haven't read recently the case that was cited about the missing witness rule, so I can't say specifically what's in it, but I am willing to bet that the missing witness rule does not apply when there's been a valid assertion of a privilege or other immunity for keeping the witness out of court. So, for example, if they tried to subpoena the defendant's lawyer and the defendant said, wait, I have attorney-client privilege, you can't subpoena him, they're not going to be able to get an adverse inference from that. And that's critical. Because as I've gone through multiple times, and we keep going back and forth on this, they keep representing that there was a blanket defiance and there was no explanation and there was no legal basis for what the president was doing. And it's just not true. There were letters back and forth. I put them up on the screen. There were specific immunities asserted. There were specific legal deficiencies in the subpoenas that were sent. And this is important because if you're going to impeach the President of the United States, turning square corners and proceeding by the law matters. And for the House managers to come here and say it was blanket defiance, it was unprecedented, that you have to draw an adverse inference against them because they didn't respond to any of our document subpoenas. All of the document subpoenas were issued without authorization. Maybe they disagree with us, but they can't just say, we provided no rationale and you have to draw an adverse inference. There was a specific legal rationale provided. And they didn't try to engage in the accommodation process, and they didn't try to go to court. And now, yes, it's true. Our position is that when they go to the court, Article III courts don't have jurisdiction over that. Their position is Article III courts do have jurisdiction over that. They believe that they can get a court order to require us to comply with a valid subpoena. But they never tried to establish in court that their subpoenas were valid. We have an assertion of a legal deficiency on one side. They think it's different. They don't want to go to court to get it resolved. We have the assertion of absolute immunity from congressional compulsion for senior advisors to the president. It's been asserted by virtually every president since Nixon. They try to say, oh, it's preposterous, it's irrelevant, we don't have to worry about that. Every president since Nixon, virtually, has asserted that. It's only been addressed by 2 district courts, trial-level courts. The first one rejected it, and its decision was stayed by the appellate court, which means the appellate court thought, probably you got it wrong, or at a minimum, it's a really difficult question, we're not sure about that. And the second district court decision is being litigated right now. They're litigating it. And when they say that when Charlie Kupperman went to court, they were trying to do something reasonable to say, oh, well, we don't want to litigate this with you. You should just agree to be bound by the McGahn decision. What's the saying, every litigant gets his day in court? Why shouldn't Charlie Kupperman get to have his counsel argue that issue on his behalf? That's what he wanted. He didn't want to say, I'm going to trust it to the other people litigating the other case. I've got my case. I want to make the arguments. But they wouldn't have that, so they mooted out the case. They withdrew the subpoena to moot out the case because they didn't want to go to the hearing in front of Judge Leon on December 10th. They've also pointed out, as if it's some outrage, that documents have been more readily produced under FOIA than in response to their subpoenas. But what that actually shows is that when you turn square corners and follow the law and make a request to the administration that follows the law, the administration follows the law and responds. And that's right. The documents were produced. Information came out. But they didn't get it because they issued invalid subpoenas and they didn't try to do anything to establish the validity of their subpoenas. If you're going to be sloppy and issue invalid subpoenas, you're not going to get a response. But if some private litigant follows FOIA and submits a FOIA request, they get a response. So to act like the Trump administration has done some blanket denial of everything simply isn't accurate, and there's no basis for any adverse inference because there's a specific privilege or basis for every reason not to produce something. Thank you.
Thank you, counsel.
Mr. Chief Justice.
Senator from New Hampshire.
Thank you, Mr. Chief Justice. I send a question to the desk for the House managers.
Thank you. The question is for the House managers. Did Acting Chief of Staff Mick Mulvaney waive executive privilege in his October 17 press conference in which he stated that there was, quote, political influence, end quote, in the Trump administration's decision to withhold aid to Ukraine?
Mr. Chief Justice, distinguished members of the Senate, I thank you for that question. Mick Mulvaney has absolutely waived executive privilege. He has never asserted executive privilege. In fact, as the President's Counsel has acknowledged, they have not asserted executive privilege once. The President's Counsel has said, when we made that point during our opening arguments, that that was technically true. No, it's true. It's not an alternate fact, it's a fact. You have never asserted executive privilege in connection with Mick Mulvaney's testimony or anyone else. It was not asserted as it relates to any of the 17 witnesses who testified, 12 of whom testified publicly. The other phony arguments that have been articulated respectfully are that the House needed to vote in order for the subpoenas to be valid. There is nothing in the Constitution that required the full House to vote, nothing in Supreme Court precedent, nothing under federal law, nothing under the House rules. It was a phony argument. Yet the House, after the initial stages of the investigation, did fully vote, and fully voted on October 31st. Interestingly enough, Mick Mulvaney was subpoenaed thereafter, not before, thereafter, after the House had voted. Subpoenaed on November 7th. Here it is. The next day, the White House responded. It responded with a 2-page letter dated November 8th. There's no mention of executive privilege in the November 8th letter. But here's what it does say. The Department of Justice has advised me that Mr. Mulvaney is absolutely immune from compelled congressional testimony with respect to matters related to his service as a senior advisor to the President. What's interesting about this letter from Mr. Cipollone is that it doesn't cite a single legal case for that outrageous proposition. A single legal case for the proposition that Mick Mulvaney is absolutely immune. Why? Because there's no law to support it. The president tried to cheat, he got caught, and then he worked hard to cover it up. The Senate can get to the truth. You can get to the truth by calling witnesses who can testify. And any privilege issues can be worked out by the Chief Justice of the Supreme Court. The American people deserve a fair trial. The president deserves a fair trial. The Constitution deserves a fair trial. That includes Mulvaney, that includes Bolton, that includes other relevant witnesses.
Manager.
Mr. Chief Justice.
Senator from Alaska.
Mr. Chief Justice, I send a question to the desk on behalf of myself and Senator Young and Senator Crapo. The question is to be directed to both parties.
Thank you. The question directed to counsel for the President and the House managers. The Constitution does not specify the standard of proof to be used in trials of impeachment, and the Senate has not adopted a uniform standard by rule. Thus, the standard of proof is arguably a question for each individual senator. In the Clinton trial, and now with President Trump, it appears that Republicans and Democrats apply different standards depending on whether the President is a member of their party. What standard of proof should be used in trials of impeachment? Preponderance of the evidence, clear and convincing, beyond a reasonable doubt, and why? I think it's the turn of the House managers to go first.
Mr. Chief Justice, Senators, there is no court case on this. The House needs strong evidence, but it's never been decided beyond a reasonable doubt, as the President's counsel has suggested. And as the question notes, the Constitution does not specify either the House's evidentiary burden of proof or the Senate's. I would note that the House Judiciary Committee held itself to a clear and convincing standard of proof in the Nixon matter, which requires that the evidence of wrongdoing must be substantially more probable to be true than not, and that the trier of fact must have a firm belief in its factuality. In the Clinton case, the House did not commit to any particular burden of proof, and I would recommend against including an express standard. Instead, like in the Clintons, simply finding the facts and any inferences from those facts without legal technicalities. It has been opined that in the end, it is up to each senator to make a judgment, and I think there is much truth to that. Your oath holds you to a finding of impartial justice, and I trust that each and every one of you is holding that oath very dear to your heart. It will find the facts and lead to a just result for our country, the Constitution, and for a future that hopefully is as free as our past has been. I yield back.
Thank you.
Mr. Chief Justice, Senators, thank you for the question. I think that the Constitution makes it clear in the terms that it speaks of impeachment are all related to the criminal law. It speaks of an offense, it speaks of conviction, it speaks of a trial in saying that crimes shall be tried by jury except in the case of impeachment. And both that and the gravity of a presidential impeachment, which is an issue of breathtaking importance for the country and could cause tremendous disruption to our government, both counsel in favor of the traditional criminal standard of proof beyond a reasonable doubt. And in the Clinton impeachment, senators, both Republicans and Democrats, repeatedly advocated in favor of that standard. Senator Russ Feingold then said that, quote, in making a decision of this magnitude, it is best not to err at all. If we must err, however, we should err on the side of respecting the will of the people. Similarly, Senator Barbara Mikulski then said, quote, the U.S. Senate must not make the decision to remove a president based on a hunch that the charges may be true. The strength of our Constitution and the strength of our nation dictate that the Senate be sure beyond a reasonable doubt. The preponderance standard is wholly insufficient. That means just 50.1%. You think it's a little more likely than not. That's not sufficient to remove the president. Even clear and convincing evidence is not. It has to be beyond a reasonable doubt. As Senator Rockefeller explained at the time of the Clinton impeachment, that means, quote, it is proven to a moral certainty the case is clear. That is the standard that the senators should apply, because the gravity of the issue before you would not permit applying any lesser standard. Thank you.
Counsel?
Mr. Chief Justice.
Senator from New Jersey.
Thank you, sir. Mr. Chief Justice, I send a question to the desk. Manager. Thank you.
The question is for the House Manager. Even if a communication or a document is covered by executive privilege, that privilege can be overcome by showing the evidence is important and unavailable elsewhere. On January 22nd, while this trial was underway, President Trump said, quote, I thought our team did a very good job, but honestly, we have all the material. They don't have the material, end quote. Can you comment on whether executive privilege allows a president to conceal information from Congress, particularly if the evidence cannot be obtained elsewhere?
Thank you, Mr. Chief Justice, and I thank the distinguished senator from New Jersey for his question. President Trump alone has the power to assert executive privilege. And as the counsel admitted on Saturday, the president has not formally invoked it over any document requested in this impeachment inquiry. It's not been asserted as it relates to any single document. Now, executive privilege gives President Trump a qualified form of confidentiality when he does get advice from his aides in order to carry out the duties of his office. And as I know you are all aware, it is often the case in congressional investigations that a president will claim executive privilege over a very small subset of materials. In that case, what the executive branch usually does and should do is to produce everything that it can and then provide a log of documents in dispute or permit a private review of the documents that have been contested. That's not what has occurred in this case, because the president has ordered the entire executive branch to defy our constitutionally inspired impeachment inquiry. Blanket defiance is what has taken place. And there's no right to do that. Every court that has considered the matter has asserted that the president cannot assert a privilege to protect his own misconduct, to protect wrongdoing, to protect evidence that the Constitution may have been violated. The president cannot do it. In an impeachment inquiry, the congressional need for information and its constitutional authority, of course, are at its greatest. It's imperative to investigate serious allegations of misconduct that might constitute high crimes and misdemeanors. And that is what is before you right now. Let's look at what the Supreme Court has said in circumstances that are closest to what we face today in U.S. versus Nixon, in the context of the grand jury subpoena. The Supreme Court found that President Nixon's generalized assertion of privilege must yield to the demonstrated need for evidence in the pending trial. And the federal court here in D.C. has recognized that Congress's need for information and for documents during the inquiry is particularly compelling. Briefly, any argument that every single document requested by Congress is subject to privilege or some form of absolute immunity is absurd. There are calendar invitations, scheduling emails, photographs, correspondence with outside parties like Rudolph Giuliani. These are all important pieces of evidence for you to consider. Proceeding documents like Ambassador Bolton's notes, Lieutenant Vindman's presidential memo should also be provided to you so you can seek the truth, the whole truth, the truth.
Mr.
Mr. Chief Justice.
Senator from Louisiana.
Senator Moran, my colleague from Kansas, and I send a question to counsel for the president.
Thank you. The question for counsel for the president is, what did Hunter Biden do for the money that Burisma Holdings paid him?
Thank you for the question. Chief Justice, Senators, as far as we know, Hunter Biden has said he, quote, attended a couple board meetings a year, end quote. Here's what we know. Hunter Biden did attend one board meeting in Monaco. We also heard that when in Monaco, we also know that Hunter Biden went on a fishing trip, and he took his daughter and his nephew. So he took two of my children with him on a fishing trip to Norway with Zolchevsky, and that is as much as we know, other than his statement that he attended one or two board meetings. Factually, that is what he said, and the timeline shows that, again, Devin Archer was on the board with him, and then Hunter Biden remained on the board, but factually in the record, that is as much as we know that he did involving Burisma and Zolchevsky. The Norway trip was June of 2015. He remained on the board until April of 2019. We also know that prior to then, a Ukrainian court in September of 2016 canceled Zlochevsky's arrest warrant. We also know December 15th, Vice President Biden called President Poroshenko, and then mid-January 2017, Burisma announces all legal proceedings against the company and Zlochevsky had been closed.
Democratic leader is recognized.
Question to the desk for both the counsel for the president and the House managers.
Thank you. The question reads as follows. The House managers say the president demands absolute immunity. The president's counsel disputes this. Can either of you name a single witness or document to which the president has given access to the House when requested? I believe it's time for counsel for the president to go first.
Mr. Chief Justice, thank you, Minority Leader Schumer, for the question. And let me try to be clear and distinguish a couple of things. The House managers have said there was blanket defiance. That's the way they characterize it. Just, we're not going to give you anything, and that's all we said. It was just blanket defiance. We're not going to respond. What I've tried to explain several times is that that was not the president's response. There were specifically articulated responses to different requests based on different legal rationales because there were different problems with different subpoenas. So one problem is all the subpoenas up until October 31st were not validly authorized. So those subpoenas, we said, we're not going to respond to those because they weren't validly issued. It wasn't an assertion of executive privilege. It wasn't an assertion of absolute immunity. It wasn't anything else. It was the fact that they weren't validly authorized. They pointed out that, we subpoenaed, I think it was, they mentioned Acting Chief of Staff Mulvaney after October 31st. That's true. We didn't rely on the fact that the subpoena was not authorized. We pointed out the doctrine of the absolute immunity of senior advisors to the president. This is not some blanket absolute immunity for the entire executive branch. It doesn't apply to all of the subpoenas they issued. As we explained in our brief, it applies to 3. There were 3 people they subpoenaed as witnesses that was on this basis alone that the president declined to make them available. Acting Chief of Staff Mulvaney, the legal advisor to the National Security Council, John Eisenberg, and the Deputy National Security Advisor, Mr. Kupperman, I believe, but it's in our brief. It was those 3 who had immunity. A doctrine asserted by every president since Nixon. Then there was a different problem with some of the subpoenas. Some of the other witnesses who were not senior advisors to the president did not assert that they had absolute immunity. Instead, those subpoenas refused to allow those executive branch personnel to have executive branch counsel accompany them. And there's an OLC opinion, it's been published, it's online, it's cited in our trial memorandum saying that it is unconstitutional to refuse to allow the executive branch personnel to have the assistance of executive branch counsel to protect privileged information during the questioning. And therefore, it's not valid to force them to appear without that.
Thank you, counsel.
Thank you.
Mr. Chief Justice and Senators, you know, we've received nothing as part of our impeachment inquiry. It's worth pointing out that the House committees that subpoenaed before the House vote had standing authority under the House rules, and they were the Oversight Committee, which has, under its standard authority, to investigate any matter at any time, as well as the Foreign Affairs Committee, They had the authority under the rules of the House adopted January 11th to issue subpoenas. They did, and they were defied. The idea of absolute immunity has never been upheld by any court, and it's really incomprehensible to think that somehow this concept of absolute immunity has lurked in hiding for centuries for presidents to use it in this day. It's, when you think of the two cases, the Myers case and the McGahn case, courts completely rejected the idea of absolute immunity. On slide 38, if you could, there is a decision recently made in the McCann case, and here's what it says. Stated simply, the primary takeaway from the past 250 years of recorded American history is that presidents are not kings. That's the judge's words, not mine. Compulsory appearance by dint of a subpoena is a legal construct, not a political one, and per the Constitution, no one is above the law. The president is not permitted by the Constitution or by the law to assert any kind of absolute immunity. That does not exist in America. And as the judges pointed out, that would be something that a king would assert. I'm not saying that, but I will say this. It's something our founders set up our checks and balances to prevent. Nobody has absolute power in our system of government, not the Senate and House, not the president, not the judiciary. This is unprecedented and just wrong as a matter of law and as a matter of the Constitution. Thank you.
Thank you.
Mr. Justice.
Senator from Georgia.
Thank you, Mr. Chief Justice. I send a question to the desk for both the Counsel of the President and the House managers on behalf of Senator Cruz and myself.
Thank you. The question is, you refuse to answer the question on political bias. Are the House managers refusing to tell the Senate whether or not the so-called whistleblower had an actual conflict of interest? There are 7 billion people on planet Earth. Almost all had no involvement in Biden's quid pro quo. Are the House managers unwilling to say whether the so-called whistleblower was a fact witness who directly participated in and could face criminal or civil liability for Joe Biden's demanding Ukraine fire the prosecutor who was investigating Burisma? And why did you refuse to transmit to the Senate the Inspector General transcript? Which side is, it's addressed to both sides. I think perhaps the House managers could go first.
With respect to the ICIG, the President and his allies have tried to shift focus to the Inspector General of the intelligence community, a highly respected veteran of the Justice Department and his handling of the whistleblower complaint. There was an effort to insinuate wrongdoing on the part of the whistleblower, and there's been an effort to insinuate wrongdoing on behalf of the Inspector General. The briefings that we had with the ICIG related to the unusual and problematic handling of this particular whistleblower complaint within the executive branch, which diverged sharply from any prior whistleblower complaint by anyone within the intelligence community. The Intelligence Committee is continuing its ongoing oversight to determine why and how this complaint was initially concealed from the committee in violation of the law. ICIG Michael Atkinson continues to serve admirably and independently as he is supposed to do. Like the Senate Intelligence Committee, the House Intelligence Committee does not release the transcripts of its engagements with inspector generals on sensitive matters, because doing so risks undercutting an important mechanism for the committee to conduct oversight. The transcripts remain properly classified in conformity with IC requirements to protect sensitive information. The ICIG made every effort to protect the whistleblower's identity and briefed us with the expectation that it would not be made public, and we are trying to honor that expectation. With respect to allegations of bias on the part of the whistleblower, let me just refer you to the conclusion of the Inspector General, which is, after examining the whistleblower's background, any potential allegations of any bias, the whistleblower drew two conclusions. The whistleblower was credible, meaning that whatever issue, perceived or real, the Inspector General found that whistleblower credible. The Inspector General also found that the whistleblower's complaint was urgent and that it needed to be provided to Congress. The Inspector General further found that it was withheld from Congress in violation of the law, in violation of the statute, and for that, he is being attacked. Now, counsel for the President rely on an opinion of the Office of Legal Counsel as its justification for violating the Whistleblower Protection Act and not transmitting the complaint to Congress.
Thank you, Mr. Manager.
Mr. Chief Justice, members of the Senate, on page 5 of the Inspector General's report, it states, although the Inspector General's preliminary review identified some indicia of arguable political bias on the part of the complainant. Now, that's in the actual statement. He goes on to say, involving a rival political candidate, such evidence did not change his view about the credible nature of the concern or what appears to be credible. But to argue that it does not include an issue of political bias, the Inspector General himself says that that's, in fact, at least that they said that their preliminary reviews indicate some political bias. Now, there's been reports in the media that the individual may have worked for Joe Biden when he was vice president. He may have had some area under his watch involving Ukraine. But I also thought it was just interesting that managership just talked about the importance of how they control the process as it relates to whistleblower reports because of the sensitive nature of those. Do we not think that the sensitive nature of information shared by the President's most senior advisors should not be subject to the same type of protections? Well, of course, it has to be. Thank you.
Thank you, counsel.
Send a question to the desk for both the President's counsel and the House managers. Thank you.
The question from Senator Manchin reads as follows. The framers took the words high crimes and misdemeanors straight out of English law, where it had been applied to impeachments for 400 years before our Constitution was written. The framers were well aware when they chose those words that Parliament had impeached officials for high crimes and misdemeanors that were not indictable as crimes. The House has repeatedly impeached and the Senate has convicted officers for high crimes and misdemeanors that were not indictable crimes. Even Mr. Dershowitz said in 1998 that an impeachable offense, quote, certainly doesn't have to be a crime, end quote. What has happened in the past 22 years to change the original intent of the framers and the historic meaning of the term high crimes and misdemeanors? It's counsel for the President's turn.
What happened since 1998 is that I studied more, did more research, read more documents, and like any academic, altered my views. That's what happens. That's what professors ought to do. And I keep reading more, and I keep writing more, and I keep refining my views. In 1998, the issue before this Senate was not whether a crime was required. It was whether the crime that Clinton was charged with was a high crime, When this impeachment began, the issue was whether a crime is required. Actually, 2 years earlier in a book, and then in an op-ed, I concluded, not on partisan grounds, on completely academic grounds, that you could not impeach for abuse of power, and that a technical crime was not required, but criminal-like behavior was required. I stand by that view. The framers rejected maladministration. That was a prime criteria for impeachment under British law. Remember, too, the British never impeached prime ministers. They only impeached middle-level and low-level people. So the framers didn't want to adopt the British approach. They rejected it by rejecting maladministration. And what's a metaphor, or what's a synonym for maladministration? Abuse of power. And when they rejected maladministration, they rejected abuse of power. Mr. Congressman Schiff asked a rhetorical question, can a president engage in abuse of power with impunity? In my tradition, we answer questions with questions, and so I would throw the question back. Can a president engage in maladministration with impunity? That's a question you might have asked James Madison had you been at the Constitutional Convention. And he would say, no, a president can't engage in that with impunity, but it's not an impeachable crime. Maladministration is not impeachable, and abuse of power is not impeachable. The issue is not whether a crime is required. The issue is whether abuse of power is a permissible constitutional criteria, and the answer from the history is clearly, unequivocally no. If that had ever been put to the framers, they would have rejected it with the same certainty they rejected maladministration.
Was of power. The first draft of the Constitutional Convention said treason or bribery. That was rejected because it wasn't inclusive enough. Mason proposed maladministration, found too vague. So they said high crimes and misdemeanors. That was a well-understood term in English law. It was a well-understood term in the Warren Hastings impeachment going on in England right then. And it meant primarily abuse of power. That is the main meaning of high crimes and misdemeanor. Charles Pinckney said, those who behave amiss or betray their public trust. Edmund Randolph misbehaves. But I quoted Justice Story the other day. Every impeachment in American history has been for abuse of power in one form or another. The idea that you have to have a crime, bribery, is right there in the Constitution. Treason, bribery, other crimes. Bribery was not made a statutory crime until 1837, so it couldn't have been impeachment. The fact of the matter is that crimes and impeachment are two different things. Impeachments are not punishments for crimes. Impeachments are protections of the Republic against the president who would abuse his power, who would aggrandize power, who would threaten liberty, who would threaten the separation of powers, who would threaten the powers of the Congress, who would try to arrogate power to himself. That is why punishment upon conviction for impeachment only goes to removal from office. Can't put him in jail, as you could for a crime. You can't fine him, as you could for a crime. They are two different things. An impeachable offense need not be a crime, and a crime need not be an impeachable offense. Two completely different tests, understood that way throughout American history, and by all scholars in our history, except for Mr. Dershowitz.
Thank you, Mr. Manager. The senator from North Carolina.
Mr. Chief Justice, I send a question to the desk for the counsel of the President.
Senator Burr asks, we've seen the House managers repeatedly play video clips of Acting Chief of Staff Mick Mulvaney's press conference in which they claim he said that there was a quid pro quo. How do you respond to the House managers' allegation that Mr. Mulvaney supported their claims in his press conference?
Chief Justice. Members of the Senate, Senator, thank you for the question. We respond as Mr. Philbin did earlier today with that, which is
it involves corruption of all kinds, and it is complicated.
Statements.
But the fact is that there's been a deliberate effort to keep this information from you and to lie about it.
Yes, Monday.
These witnesses that I am going to discuss and present to you as if it were a trial have all wanted to come to the United States and were blocked by the American Embassy, by the State Department, by the FBI to some extent, and even when they hired a lawyer to present it to the Justice Department, and even though the lawyer made it clear that this involved intrusions, proven intrusions in the 2016 election, that it involved activity by then Vice President Biden that was involved in the collusion as well as corruption. Even though these things were mentioned, the Justice Department did nothing to follow up on it. It seemed that all they were interested in were the false allegations of collusion by Russians. And so you've been deprived of this evidence, and I've been attacked, as you know, seems like monumentally for being the messenger, for having had the, I think, good fortune to develop this information, because something has to be done about it. So let me tell you how it began, and then let me get to the opening statement. This all began in November of 2018. I was brought the information. The idea that I went looking for dirt on Joe Biden, or that President Trump wanted me to look for dirt on Joe Biden is totally false, and a part of the conspiracy to cover up the rather vast crimes of Democrats in the Ukraine. This information was brought to me. If you want to call it dirt, the dirt was handed to me, and it wasn't dirt. It was probable cause that crime was committed. It was given to me by reliable sources. All that I'm going to explain to you came from that. And I began investigating it in November of 2018 as a defense lawyer for the President of the United States, who was also
Bolton never informed Mick
a close personal.
of any concerns surrounding Bolton's purported August conversation with the president. Nor did Mr. Mulvaney ever have a conversation with the president or anyone else indicating that Ukrainian military aid was withheld in exchange for a Ukrainian investigation of Burisma, the Bidens, or the 2016 election. Furthermore, Mr. Mulvaney has no recollection of any conversation with Mr. Giuliani resembling that reportedly described in Mr. Bolton's manuscript, as it was Mr. Mulvaney's practice to excuse himself from conversations between the president and his personal counsel to preserve any attorney-client privilege. So I wanted to read those statements in full so that everyone had the full context. Even after Mr. Philbin referenced the statement after the press conference, the House managers again came back and said Mr. Mulvaney indicated or admitted there was a quid pro quo. That's not true. If Mr. Mulvaney misspoke or if the words were garbled, he corrected it that day and has been very clear. Thank you. Thank you, Mr. Chief Justice.
So,
Mr. Chief Justice.
the senator from Maryland.
Mr. Chief Justice, I send a question to the desk for the President's counsel and the House managers.
The question to both parties, the House managers will go first. What did National Security Advisor John Bolton mean when he referenced whatever drug deal Sondland and Mulvaney are cooking up on this, end quote, and did he ever raise that issue in any meeting with President Trump?
Mr. Chief Justice, Senators, when John Bolton, and this is according to Dr. Hill's testimony, brought up the drug deal, it was in the context of a July 10th meeting at the White House. There were two meetings that day. There was a meeting that Ambassador Bolton was present for, and then there was a follow-on meeting after Ambassador Bolton abruptly ended the first meeting. In the first meeting, the Ukrainians naturally wanted to raise the topic of getting the White House meeting that President Zelensky so desperately wanted. And after raising the issue, at some point, Ambassador Sondland said, no, we've got a deal. They'll get the meeting once they announce the investigations. And this is the point where Ambassador Bolton stiffened. Now, you can look up Dr. Hill's exact words. I'm paraphrasing here. But this is the point where Ambassador Bolton stiffens and he ends the meeting. Hill then follows Sondland and the delegation into another part of the White House where the meeting continues between the American delegation and the Ukrainian delegation. And there it's even more explicit, because in that second meeting, Sondland brings up the Bidens specifically. Hill then goes to talk to Bolton and informs him what's taken place in the follow-on meeting. And Bolton's response is, go talk to the lawyers and let them know I don't want to be part of this drug deal that Sondland and Mulvaney have got cooking up. So at that point, that specific conversation is a reference to the quid pro quo over the White House meeting. Now, we know, of course, from other documents and testimony about the quid pro quo about the White House meeting and all the efforts by Giuliani to make sure that the specific investigations are mentioned in order to make this happen. But don't take my word for it. We can bring in John Bolton and ask him exactly what he was referring to when he described the drug deal. Now, did Bolton describe and discuss this drug deal with the president? Well, it certainly appears from what we know about this manuscript that they did talk about the freeze on aid. And whether John Bolton understood and at what point he understood that the drug deal was even bigger and more pernicious than he thought, that involved not just the meeting, but it involved the military aid, there's one way to find out. And I would add this in terms of Mr. Mulvaney. No, maybe I'll add it later.
Mr. Chief Justice.
As 2.5 minutes.
Thank you, Mr. Chief Justice. Thank you, Senator, for the question. The question asks about what Ambassador Bolton meant in a comment that is reported as hearsay by someone else saying what he supposedly said. What we know is that there are conflicting accounts of the July 10th meeting at the White House. Dr. Hill says that she heard Ambassador Sondland say one thing. He denies that he said that. Dr. Hill says she went and talked to Ambassador Bolton, and Bolton said something to her about what was said in the meeting where he wasn't there, but he was saying something about it, calling it a drug deal. And what he meant by that, I'm not going to speculate about. It's a hearsay report of something that he said about a meeting that he wasn't in, characterizing it some way. And I'm not going to speculate about what he meant by that.
Thank you. The senator from North Dakota.
Thank you, Mr. Chief Justice. I have a question for myself, also for Senator Portman and Senator Bozeman. And it's for the President's Council, and I'm sending it to the desk.
The question from the senators is as follows. In September of 2019, the security assistance aid was released to Ukraine. Yet the House managers continue to argue that President Trump conditioned the aid on an investigation of the Bidens. Did the Ukrainian president or his government ultimately meet any of the alleged requirements in order to receive the aid?
Mr. Chief Justice.
Thanks, Senator, for the question. And the very short answer is no. But I'll explain. And I think that's clear. And I think we demonstrated in our presentations on Friday and Monday that the aid was released, the aid flowed. There was a meeting at the UN General Assembly. There was a meeting previously scheduled in Warsaw, precisely as President Zelensky had suggested, and there was never any announcement of any investigations undertaken regarding the Bidens, Burisma, the 2016 election. No statements made, no investigations announced began by the Ukrainian government. Thank you.
Thank you, counsel.
Mr. Chief Justice.
The senator from Virginia.
Mr. Chief Justice, I send a question to the desk for the House managers.
The question is, do you know about additional information related to Russia disseminating President Trump's or Rudolph Giuliani's conspiracy theories? Should the Senate have this information before we deliberate on the articles of impeachment?
Mr. Chief Justice, Senators, I think there are three categories of relevant material here. The first you do have access to, and that is the supplemental testimony of Jennifer Williams. And I would encourage you all to read it. I think it sheds light very specifically on the Vice President and what he may or may not know vis-a-vis this scheme. So I would encourage you to read that submission. There is a second body of intelligence that the committees have been provided that is relevant to this trial that you should also read. And we should figure out the mechanism that would permit you to do so because it is directly relevant to the issues we are discussing and pertinent. There's a third category of intelligence, too, which raises a very different problem, and that is that the intelligence communities are for the first time refusing to provide to the Intelligence Committee. And that material has been gathered. We know that it exists, but the NSA has been advised not to provide it. Now, the director says that this is the director's decision, but nonetheless there is a body of intelligence that is relevant to requests that we have made that is not being provided. And that raises a very different concern than the one before this body, and that is, are now other agencies like the intelligence community that we require to speak truth to power, that we require to provide us the best intelligence, now also withholding information at the urging of the administration? And that is, I think, a deeply concerning and new phenomenon. That problem we've obviously had with other departments that have been part of the wholesale obstruction, but it now is rearing its ugly head with respect to the IC. But the shorter answer to the question on, apart from Jennifer Williams, are there other relevant materials? The answer is yes. And I would encourage that you and we work together to find out how you might access them.
Thank you, Mr. Manager. Mr. Majority Leader.
Yes, Chief Justice, the next two questions, one from each side, will be the last before we break for dinner. I would ask that following the next two questions, the Senate stand in recess for 45 minutes.
Thank you. Senator from Alabama.
I send a question to the desk.
Question is directed to counsel for the President. How does the non-criminal abuse of power standard advanced by the House managers differ from maladministration, an impeachment standard rejected by the framers. Where is the line between such an abuse of power and a policy disagreement?
Thank you very much for that question, because that question, I think, hits the key to the issue that's before you today. When the framers rejected maladministration, and recall that it was introduced by Mason and rejected by Madison on the ground that it would turn our new republic into a parliamentary democracy where a prime minister, in this case a president, can be removed at the pleasure of the legislature. Remember, too, that in Britain, impeachment was not used against the prime minister. All you needed was a vote of no confidence. It was used against lower-level people. And so maladministration was introduced by Mason, and Madison said, no, it would turn us, it was just too vague and too general. Now, what is maladministration? If you look it up in the dictionary and you look up synonyms, the synonyms include abuse, corruption, misrule, dishonesty, misuse of office, and misbehavior. Even Professor Nicholas Bowie, a Harvard professor who was in favor of impeachment, so this is an admission against interest by him. He's in favor of impeachment. He says abuse of power is the same as misconduct in office, and he says that his research leads him to conclude that a crime is required. By the way, the congressman was just completely wrong when he said, I'm the only scholar who supports this position. In the 19th century, which is much closer in time to when the framers wrote, Dean Dwight of the Columbia Law School wrote that the weight of authority, by which he meant the weight of scholarly authority and the weight of judicial authority, this is 1867, the weight of authority is in favor of requiring a crime. Justice Curtis came to the same conclusion. Others have come to a similar conclusion. You asked what happened between 1998 and the current to change my mind. What happened between the 19th century and the 20th century to change the mind of so many scholars? Let me tell you what happened. What happened is that the current president was impeached. If, in fact, President Obama or President Hillary Clinton had been impeached, the weight of current scholarship would be clearly in favor of my position, because these scholars do not pass the shoe on the other foot test. These scholars are influenced by their own bias, by their own politics, and their views should be taken with that in mind. They simply do not give objective assessments of the constitutional history. Professor Tribe suddenly had a revelation himself. At the time when Clinton was impeached, he said, oh, the law is clear. You cannot charge a president with a crime while he's the sitting president. Now we have a current president. Professor Tribe got woke. And with no apparent new research, he came to the conclusion, oh, but this president can be charged while sitting in office. That's not the kind of scholarship that should influence your decision. You can make your own decisions. Go back and read the debates, and you will see that I am right that the framers rejected vague, open-ended criteria, abuse of power, and what we had is the manager made a fundamental mistake again. She gave reasons why we have impeachment. Yes, we feared abuse of power. Yes, we feared criteria like maladministration. That was part of the reason. We feared incapacity. But none of those made it into the criteria because the framers had to strike a balance. Here are the reasons we need impeachment, yes. Now, here are the reasons we fear giving Congress too much power. So we strike a balance. How did they strike it? Treason, a serious crime. Bribery, a serious crime. Or other high crimes and misdemeanors akin to treason and bribery. That's what the framers intended. They didn't intend to give Congress a license to decide who to impeach and who not to impeach on partisan grounds. I read you the list of 40 American presidents who have been accused of abuse of power. Should every one of them be impeached? Should every one of them have been removed from office? It's too vague a term. Reject my argument about crime. Reject it if you choose to. Do not reject my argument that abuse of power would destroy the impeachment criteria of the Constitution and turn it, in the words of one of the senators of the Johnson trial, to make every president, every member of the Senate, every member of Congress be able to define itself from within their own bosom. We heard from the other side that every senator should decide whether you need proof beyond a reasonable doubt or proof by a preponderance. Now we hear that every senator should
Thank you,
decide what
counsel.
abuse of power. Thank you, Mr. Chief Justice.
President. Mr. Chief Justice.
Senator from Maryland.
Chief Justice, I have a question on behalf of Senator Markey and myself that I send to the desk for the House managers.
The question is as follows. Supreme Court Justice Byron White, in a concurring opinion in Nixon versus United States, 1993, acknowledged that the Senate, quote, has very wide discretion in specifying impeachment trial procedures, end quote, but stated that the Senate, quote, would abuse its discretion, end quote, if it were to, quote, insist on a procedure that could not be deemed a trial by reasonable judges, end quote. If the Senate does not allow for additional evidence and the testimony with firsthand knowledge of President Trump's actions and intentions, would a reasonable judge conclude these proceedings constitute a constitutionally fair trial?
I think the answer is yes. I don't know that we need to look to the words of a prior justice to tell us that a trial without witnesses is not really a trial. It's certainly not a fair trial if the House moves forward with impeachment and comes before the Senate and wants to call witnesses and wants to make its case and is told, thou shalt not call witnesses. That's not a fair trial. I think that the American people understand that without reading the case law. They go to jury duty themselves every year, and they see the first thing that takes place after the jury is sworn in is the government makes its opening statement, the defense makes theirs, and then begins the calling of witnesses. I do want to take this opportunity, though, to respond to Professor Dershowitz's argument while they're fresh. You can say a lot of things about Alan Dershowitz. You cannot say he's unprepared. He's not unprepared today. He wasn't unprepared 21 years ago. And to believe that he would not have read 21 years ago what Mason had to say, or Madison had to say, or Hamilton had to say, I'm sorry, I don't buy that. I think 21 years ago he understood that maladministration was rejected, but so was a provision that confined the impeachable offenses to treason and bribery alone was rejected. I think the Alan Dershowitz from 21 years ago understood that, yes, while you can't impeach for a policy difference, you can impeach a president for abuse of power. That's what he said 21 years ago. Nothing has changed since then. I don't think you can write off the consensus of constitutional opinion by saying they're all never Trumpers. All the constitutional law professors, in fact, let's play a snippet from Professor Turley, who was in the House defending the president, and see what he had to say recently.
On abuse of power, in my view, it's clear. You can impeach a president for abuse of power. You can impeach a president for non-criminal conduct.
Okay, now, we can't argue plausibly that his position is owing to some political bias, right? I mean, just a few weeks ago, he was in the House arguing the case for my GOP colleagues that the president shouldn't be impeached. Now, he did say, well, if you could actually prove these things, and you could prove, as indeed we have, that the president abused his power by conditioning military aid to help his reelection campaign, yes, that is an abuse of power. You can't impeach for that kind of abuse of power. And that's exactly what we have here. We're not required to leave our common sense at the door. If we're to interpret the Constitution now as saying that a president can abuse their power, and I think the professor suggested before the break that he can abuse his power in a corrupt way to help his reelection, and you can't do anything about it. You can't do anything about it because if he views it as in his personal interest, that's just fine. He's allowed to do it. None of the founders would have accepted that kind of reasoning. In fact, the idea that the core offense that the founders protected against, that core offense is abuse of power, is beyond the reach of Congress through impeachment, would have terrified the founders. I mean, you can imagine any number of abuses of power. A president who withholds aid from another country at war as a thank you for that adversary allowing him to build a Trump Tower in that country. Okay, that may not be criminal, but are we really going to say that we're going to have to permit a president of the United States to withhold military aid as a thank you for a business proposition? Now, counsel acknowledges that a crime is not necessary, but something akin to a crime. Well, we think there's a crime here of bribery or extortion, conditioning of official acts for personal favors. That is bribery. It's also what the founders understood as extortion. And you cannot argue, even if you argue, well, under the modern definition of bribery, you've got to show such and such. You cannot plausibly argue that it's not akin to bribery. It is bribery, but it's certainly akin to bribery. But that's the import of what they would argue, that no, the president has a constitutional right. Under Article 2, he can do anything he wants. He can abuse his office and do so sacrificing our national security, undermining the integrity of the elections, and there's nothing Congress can do about it.
Thank you, Mr. Manager. We're in recess.
Well, so far, 54 questions have been asked of the House impeachment managers and the Trump defense team by 59 senators. Here's the card they have to fill out. Craig Kaplan of C-SPAN tweeted this out. Up here it says United States Senate impeachment trial